Basic features of Constitution not amendable. Another question which has been mooted since the case of Golaknath is whether the outside part of third fundamental right there is any other provision of Constitution of India which is immune from the process of amendment in Article 368. Though the majority of case 1 and case has overturned the majority view, the Golaknath, that the fundamental rights cannot be amended under the Article 368, it is affirmed. Another proposition asserted the majority of Golaknath case, namely, is there are certain basic features of the Constitution of India which cannot be alterated in exercise of power or amend it under Article 368. If therefore the Constitution Amendment Act seeks to alter the basic structural framework of the Constitution, the court would be entitled to annul it, and ground of ultra vires because the word of amendment is Article 368 means only changes other than altering the every structure of Constitution, which would be tantamount to making a new Constitution. These basic features, without being exhaustive, are the sovereignty and territorial integrity of India, the federal system, judicial review, and the parliamentary system of government. Applying this doctrine that the judicial review in the basic feature of the Constitution in India, majority of case 1 and case held the second part of the Section 3 of Constitution 25 Amendment Act 1970 relating to Article 31C is invalid. The portion so invalidated read, and no law containing a declaration that is for giving effect to such policy shall be called in question in any court on the ground that does not give effect to such policy. Article 31C, which was introduced by Section 3 of the 25th Amendment Act, provided that if any law seek a implement to the directives or principle contained the Article 39BC is regarding socialistic control and distribution of the material or resources of the country, such law shall not be void on the ground of contravention of Article 14 and 19. It is further provided that any body of challenges, provided that if anybody challenges the constitutionality of any such law, the court would be precluded from the entering even into the parliamentary question, namely whether such law is in fact a law giving effect to Article 39BC, if on the face of act there was no declaration by the legislator that it is giving the effect of such directives of policy in such words by adding declaration to an act. The legislature was empowered by the Constitution 25th Amendment Act to deprive the court of their power to determine the validity of the act on the ground that the contravened some provision of the Constitution. The majority of case 1 held that Article 368 did not confer any such power to take away judicial review in the name of amending the Constitution. The foregoing view of the majority of case 1 and case as to basic feature to debatable inasmuch as there is no express limitation upon the amending power conferred by Article 361 if the supposed that there are some implied limitations. It is a difficulty to appreciate how to court, after holding that the fundamental rights did not constitute such the unavoidable part of the Constitution, could come to the conclusion that the judicial review, such as the adjudicant of the fundamental rights, could be so considered. It would be therefore no wonder if another full bench of the Supreme Court comes to overturn that the view of case 1 and case on the grounds in that Article 368(1) as the States amended in 1971 make it is clear that not only the procedure but also the power of amend Constitution is conferred by the Article 368 itself and cannot be deprived from the somewhere else, such as the Article 245. Hence the limitations, if any, upon the amending power must be found the Article 368 itself and not from any theory of implied limitations. That is the word repeal in Article 361 from makes it is clear amendment under the Article 368 includes the repeal of any such provision, including any supposed basic of essential provision. That is, the Constitution of India makes the distinction between the amendment and total revision. as do some other constitutions, such as the Swiss constitution. Hence, there is no bar to change whole constitution. It exercise of the amending power, which describe the constituent power, Article 361, that accordingly it would be necessary convene the Constituent Assembly to revise the constitution in toto. The 42nd Amendment, the Indira Gandhi government sought to arrest these implications of Kesavananda, cut the fetters sought to be imposed on the sovereignty of Parliament as the constituent body by inserting by 2 clause 4 and 5 Article 368 and 42nd Amendment Act 1976. Clause 5 declares that there shall be no limitation on the constituent power of the Parliament to amend. The provision of the Constitution, that is, the any rate validity of the No Constitution Amendment Act, shall be called accusation in the any court or any ground. Clause 2 4. Foregoing attempt to preclude judiciary review of the Constitution Amending Act has, however, been nullified by the Supreme Court by striking down the clause of 4 and 5 inserted by Article 368 and by the 42nd Amendment Act by its decision in the Minerva Mills case on the ground of that judicial review in a basic feature of the Indian constitution system, such as cannot be taken away even by amending the constitution. So far, decision in Kesavananda has been followed by subsequent cases in Supreme Court. As a result, Article 368 is so interpretation by the highest court leads to following proposition. Any part of the Constitution may be amended after the complying with the procedure laid down by Article 368. Article 368 as interpreted by the Supreme Court. No referendum or references to a Constituent Assembly would be required to amend any provision of the Constitution. But no provision of Constitution or any part of therefore can be amended if it takes away or destroy any of the basic features of the Constitution, thus apart from the procedural limitation expressly laid down by the Article 368, by the substantive limitation found and by the doctrine of basic features has been introduced into our Constitution. By judicial innovation, the Constitution values and overarching principle would fall outside the amending power under Article 368 of the Constitution. The Parliament cannot be amended the Constitution to abrogate these principles so as to rewrite the Constitution. A list of basic features. The Supreme Court has refused to foreclose its list of basic features from the various decisions. So far, the following list may be drawn up. Supremacy of Constitution, rule of law, the principle of separation of power, the objective specified in the preamble to the Constitution, judicial review, Article 32 and 226 and 227, federalism, so secularism to sovereign, democratic, republican states, and freedom and dignity of individual, unity and integrity of the nation, the principle of equality, not for feature of equality, but the quintessence of the judicial equal justice, the essence of other fundamental rights in part of third. In the concept of social and economic justice to build a welfare state in part fourth in toto. The balance between fundamental rights and directive principle, the parliamentary system of government, the principle to free the fair election, the limitation upon the amending power the conferred by Article 368, independence of the judiciary but within the four corners of the Constitution and not beyond that, effective access to justice. Power of Supreme Court under the Article 32, 136, 141, 142. Legislation seeking to nullify the award made by exercise of the judicial power of the state. Legislation seeking to nullify the award made by exercise the judicial power of the state arbitration tribunal constituted under the Act. Reasonableness, social justice, Article 25, write down, read Article 14, 19, Article 15, 14, write down, Article 14, 4A, and 4B, Article 20 and 32 as a principle or essence of the underlying them. The balance provided for between the part third fundamental right and part fourth directive of principle. The history of amendments of the Constitution since 1950. Since the commencement of 26th January 1950 Constitution in India has been amended 05 times till December 2021. The passing act the Parliament in the manner prescribed in Article 368. See the table for past. Since all these amendments act have been mentioned with full particulars, table 4th post is needless to reproduce them to present chapter. The 42nd Amendment. Nevertheless, the 43rd and 44th Amendment must be given a fuller treatment in view of its serious repercussion in the political as well as legal world. All previous amendment paled into the insignificance after the passing of the 42nd Amendment Act 1976, which alone would be illustrate how momentous the amending power under the Indian Constitution is and how easy it is change intensive and vital provision of the Constitution without any elaborate formalities when the ruling party has a comfortable majority in the two houses of parliament. The 42nd Amendment Act was particularly a revision of the Constitution for the following in extent of introduced changes in the preamble, as many as 53 articles, as well as the 7th schedule, as to substantive changes in sought to change the vital principle underlying the 1949 Constitution.